All right, we've assembled here in the courtroom in the absence of the jury. The defendant is present with his lawyers and the state prosecuting attorneys, special prosecuting attorneys present, as is Mr. Shiver. I don't, did the council feel like we would go through these tapes, or not tapes, but recordings to, in the absence of the jury, to have rulings on them, or how did you intend to do this would be a question I would have. And then I'm not sure whether you're going to have a witness to, whether these are going to be authenticated, who's talking and so forth, and times and so forth by a witness, or whether it's by stipulation, or just how you intended to do this.
Yeah, Your Honor, we intend to call Julia Evslage, who's testified previously, and in fact, for the 2017, I think some of the recordings for that, we had done it through that witness. So she's the one who listened to them and transcribed them and such. So, and was a monitor of, I mean, obviously she didn't monitor every school call that was accumulated in 2018, but she was one of the subject matter experts present for the monitoring in 2018.
Okay, I'm just not sure though, at some point, maybe she'll be testifying in front of the jury, but at some point, are we going to consider these before, in the absence of the jury?
I thought that was the whole purpose, was for them to identify any that they disagree with or make any arguments they want about the listening aids.
That's what I had thought also.
Yes,
so I don't know, is that the way we're going to do this? I want to note one thing too, and that was that one of these recordings, number 3171, I think was absent from the last group of recordings I received, although it had been in one of the earlier groups, assuming that it, and it's the next to last one on the list here, so assuming that it begins at 1455 to one-page transcript, begins with the word Jake either way and ends with George out of it. Does that look right?
Yes, Your Honor. And that actually should have been in your first batch.
It was in the first
Okay.
batch, wasn't in the last batch.
Oh, sorry, Your Honor.
So so we have, but I did get a copy of it from the first batch tonight. All right. So I will hear from counsel for the defense then. You wish to go down through these in the order in which they appear, which I also understand is probably chronological order.
Yes, Your Honor.
I'll let Mr. Nash address a lot of these, but I just want to put a couple of general things.
All right.
I think we received 20 additional transcripts a couple hours ago when we broke. We've been able to review those over the lunch hour, although we didn't have much of a lunch hour, obviously, to do all that, but we did that. We did, in conjunction with one of the ones we just received today, obtain a document which we believe is relevant. And so we need to give a copy of that to the prosecution. But that was based on a transcript that we got today, so we'll do that. And we don't, some of these we're not objective to because they're clear. We think most of them are clear enough to where no listening aid is needed whatsoever. There are many that we object to for various legal reasons, we explain them. But for example, the ones we were given today, I think all of those are clear enough that there is no need for listening aid on any of the ones we received today. And as a general statement, the transcripts we received that were one phone call from one person to another that were recorded direct phone calls, those are very clear as a general rule. The ones that appear not to be so clear at times, some of them, not all of them, are the listening devices in the R9 truck. Sometimes those are unclear, and we'll identify which ones we think that's a problem. But we don't think a listening aid is needed for any of the ones that we provided today that help make our review faster, quite honestly. But we can address each of them individually, but also we had a motion to suppress these items before trial. So I want the record to be clear, we're not waiving that objection with respect to these various recordings, but just because we may not be objecting to particular ones, we still maintain our prior position.
All right. Well, let me ask the state's counsel here. You know, the 20 or so that were provided today of these 40-some, I think they're 47. I mean, I haven't heard them, so I don't know. You have heard them presumably, so I don't know. I mean, if they're clear, then a listening aid not only would not be needed, but might not even be appropriate. So.
You know, to that end, Your Honor, the thing I would say is sometimes there's multiple individuals talking. You know, a lot of times when Jake's in the truck with George, or vice versa, when George is in the truck with Jake and Angela's on the phone with them, or Billy's on the phone with them, there's sometimes, you know, multiple people talking, like, you know, George will chime in on the phone call or whatever. And again, because Ms. Everslade has so many hours listening to these people, she can identify who the voices are. And so rather than have her go back and say, okay, who was it that said this part of I mean, it just seems to me to make sense, you know, rather than pick out, well, oh, this one sounds clear. Well, you know, then we get in the middle of it and it's, you know, there's parts of it that aren't clear or whatever. To me, again, with the cautionary instructions that the court is going to give the jurors, them having this is only going to be helpful, you know, if nothing else than to identify who is speaking at various times. So,
Most of the phone calls, I think, are just between two people.
well,
Most of them. There are a couple that are.
I mean, it doesn't hurt for them to have this listening device, and it can only help them.
Well,
Do
because
they
it's
use
clear,
it
I don't
to-
think it's necessary, I don't think it's proper. I mean, when George and Jake are talking, you can clearly tell the difference between them.
Well, you can tell the difference.
All right. Well, in the ones that are clear, you've listened to them and you've looked at the transcripts. So are there differences in the last 20 or whatever you were given today, which you said you thought were 20? Are there differences between the transcript and the clear report?
I don't think there are significant differences, but my understanding of the case law is that the evidence are the recordings.
That the evidence is the recordings. Unless the state has some law that you can cite to me otherwise, my view of these listening aids was exactly that, is that they may use these listening aids here to determine what these recordings do. They can take notes if they wish to concerning what these recordings do, and the recordings can go with them to the jury room to listen to again. But my idea of taking a transcript to the jury room, that's not what these are for. And unless you can find me some case that clearly says that they're to take these back, we can have them marked for, I suppose, for purposes of the record, but to determine, you know, that they were accurate. But I don't think the jury should have those back there, because I'm sure they would shortcut that and just look at the transcript.
And Your Honor, we don't disagree with that. I maybe misunderstood.
Yeah.
We just are seeking to use them today, you know, as a listening aid for today.
Okay.
But I think the court's going to give them an instruction about that, and then we would
Well, I'll
not.
also instruct them that they will not have these with them in the jury room. They will have the recordings, but
Right,
not the transcript.
Just make our
We agree with
position clear. On the recordings that are clear, there should be no listening. There shouldn't. There's no need. And oftentimes, you know, there's like, the people talking identify each other. Mom, this, George, this, Jake, shut up, George, shut up. You know, you can tell who's talking.
I mean, as far as just identifying, again, it's hit and miss, so they're not pointing out that there's any inconsistencies.
All right.
I'm just gonna say, this is a tool that clearly will assist the jury in better understanding the evidence. I don't understand why we wouldn't give the jury a tool that would assist them in helping them understand what we believe is relevant evidence.
Well, nobody's really cited any particular law either way, but I'm going to permit the jury to use these as a listening aid. And to all these, but not to take them, they will not be available to the jury in the jury room. The only thing available to them there will be the tapes themselves, and I will give them an instruction before they listen to anything that these are listening aids only, and they're not the evidence. The evidence is the tape. Now,
From a presentation point of view, we have the transcripts for each one of the recordings here available. Again, I would suggest that maybe the bailiff, we would give the bailiff, whichever one we're going to use, the bailiff distribute them, and the bailiff take them back when we're.
We need the bailiff in here to do that.
Yes.
Now, shall we go through these and argue? It's going to take a little bit of time to do that, I think, to argue.
Yeah.
So, all right, we'll allow the defendant's attorneys to argue.
Judge, my suggestion is, I think the court may have a copy of chronological order.
I do have. Yeah.
Oh, okay. My suggestion would be that we just start with the first one, which is 543. And with that one, we have an objection to the relevance of that. It appears to be, there's been prior testimony that's been uncontested. It appears to be an improper, consistent statement. Nobody's challenged the evidence in that, of the testimony. And so therefore, it's just reiterating what's already been said. Other than that, it's irrelevant on 543.
All right, then the state would argue what with respect to you're talking 543, right?
543.
Yeah. Your Honor, so basically a whole lot of these are going to be, anytime it's George involved in the conversations, our argument is going to be, first of all, it's a defendant's statement. And second of all, we ascribe some importance to it because it evidences, again, just how they work as a unit. In opening statements, we heard that, he's trying to distance himself from his family, et cetera. He's not part of the fold, and these kind of things just show how intertwined they all are.
And, well, first off, even if it's defendant's statement, it doesn't mean that we skip the probative value of a statement. It's irrelevant, even though it may contain a defendant's statement. That's not an exception. But in moving on to the defendant or the co-defendants acting as a unit, this fails to even establish that. And so we would ask that this would be moved.
How does this aid in establishing a fact that's relevant to this case? I'm trying to understand how it does. Talking to your mother about your job and what you're making just somehow indicates that they're working together on something.
Well, he's also in there, Your Honor, he's selling converters. Catalytic converters. That's the very last part of that sentence is he's selling catalytic converters.
Okay.
The beginning is him asking his mom to ask his grandmother for money, because he's waiting for the money from the insurance stuff. And, it evidences, again, just this rude family conversation. I mean, obviously we think it's relevant or we wouldn't be seeking to admit it, but it's just, the accumulation of evidence to suggest that nowhere in here is there, discord. And, the defendant's statement doesn't have to be inculpatory on its face for it to be probative and for the state to be able to use it, so.
The state raises a good issue. It is cumulative. And cumulative evidence shouldn't be admitted. And so for whatever value it is, it would be cumulative. But so what? He sold catalytic converters. I still struggle to see the relevance. But there is a discussion about insurance money. George asking for a check and insurance money comes in.
Yeah.
This recording was on May 30th.
Again.
This is part of what we wanted to provide.
All right, okay, so you're objecting to this. I'm going to overrule the objection there. There is a discussion about insurance money. There was some evidence about obtaining insurance money improperly and so forth and so on.
Judge, this was part of the supplemental discovery we have. It's dated May 27th of 2018, where George Wagner IV was in an auto accident.
Yeah.
And so that stems with the insurance claim.
Yes, this is in reference to what I said earlier, that this is one of the recordings we were given today.
Right.
And the date of this recording is
May 27th. Oh, the recording is May 30th.
the date of the recording is May 30th, and he was in a traffic crash report we have from just
Oh,
a
so
few
that's-
days before that we obtained once we saw it. We were able to obtain them so that the contract. So we're happy to share this with the state. We did earlier because we didn't know they would use this particular recording, but he was in a car crash. He was not at fault. And that's the reference to the insurance.
All right, okay.
So, I mean, you're welcome to look at that. That's on the copy.
You're welcome to introduce this in your case.
But, you know, it's one of the problems that appears periodically throughout these, is that these excerpts are vague and ambiguous.
Well, it's
And
not.
open up.
He's saying that he's getting in, he wants to borrow money from his grandmother, and he wants his mother to ask him for him. While he's waiting for the, insurance money. This was an accident at the end of Avenue 9. What is it?
So he had an accident, damaged something, he's getting an insurance check, and he wants to borrow money from his grandmother until his insurance check comes in. And that's relevant how to this case?
Well, again, Your Honor, because we talked about how their finances are all intertwined, because they are. And they've resisted that. And so I think the state should be able to demonstrate that that is true. And, you know, I don't know if this is a legitimate crash. We were just handed this, obviously. But, you know, I mean, Jake and Chris Newcomb crashed in George's truck, and that wasn't legit. So I don't know that it would be
It's
an
a genuine report prepared by the Highway Patrol.
That doesn't matter. Chris Newcomb was life-flighted. That doesn't make the wreck legit.
I don't, especially if that shows an auto accident at the same time, I don't see the relevance of it.
But, Your Honor, you are aware that our argument is that the.
I understand what your argument is, but I don't see how this lends anything to it. Out of context, I don't see how
Well,
this does.
how is it prejudicial to the defendant?
Because you're trying to.
Really, I don't care.
Some sense
The
to
point is you can't introduce something based on the standard that it's not prejudicial to the defendant, but we'll be here for months.
Well,
The idea is it relevant to the case that we've got in front of us?
I mean, obviously, we wouldn't be wanting to admit it if we didn't.
If you didn't think it was, but I don't see it.
Okay. So the catalytic converters, which is, I'm sure the court knows, is something that people generally steal from people and sell them. I mean, we've had testimony that George would be out all night, all hours of the night, that came from Beth Ann, and that he and Chris would be scrapping.
I don't think we can jump to the conclusion that these are stolen. All these things that he's referring to here are stolen.
And then we come with 15 catalytic converters, or
All right.
15 converters.
I'm going to sustain the objection to 543. Now, 464.
This is a conversation between Beth and Jake. We also objected to this in regard to relevance. This is in regard to the one where there's weekly. Oh, it's Beth and Jake talking about how difficult it is for Beth to live in the home with Angela. We would object to give this relevance for this.
Object to what?
Relevance. It's just a conversation between Beth and Jake, where Beth is essentially grumbling about difficulties of living with Angela.
With that, I'm going to overrule the objection to 464. Your objection has to do with relevance? I'm not sure what the basis of it is.
It is,
It's just prior consistent statements, and this has been testified to already.
I'm going to overrule the objection before 64. 471.
we have no objection to that.
And now 621.
621, we do not have an objection.
And 626.
That, can we come back to 626?
Right. No, let's see, the next one is 44.
Irrelevant. It was clear enough, we had no problems with that, just irrelevant. So we asked the state to probe the value.
We would say this is highly relevant, Your Honor. This is George chastising Jake for not believing his daughter and not being protective of his daughter, and, you know, regarding that being reportedly touching her. So again, it just shows, I'm trying to see what else is in here.
Well, I'm going to overrule the objection to it. I'm going to give it to Clay. 150 is the next one.
150, the only objection we have to that is that we would like that entire conversation played, because it's a 21, almost 22-minute phone call, and they want to use about 3 or 4 minutes of that. We believe the entire conversation is required to put that 3 or 4 minutes in context.
And the state's argument is what?
I haven't listened to this 20-minute thing recently, so I don't, the things that we are, have isolated here, and again, you know, I'm not sure how 20 minutes is going to be all relevant, but George is upset because they're having Beth call, or Sophia called Beth mine.
Is there some ability to play? I'm not sure how you have these things set up, but if, for example, if I sustain an objection to something, is that something that can be skipped, or do we have separate? I mean, I don't know how they're.
Yeah, no, she's trimmed the video or the audio down to whatever is indicated here.
No, all right. I'll rule on that in a moment. Then we'll see whether it's possible to play that entire thing or not. 1436.
Just take a few seconds for that call.
Say it again.
I'm looking for that transcript here. Was that one provided to us Friday? Do you know?
It was.
can't try the language that we objected to, just note our objection on the record for that.
I'm sorry, did you?
We just got an objection that's irrelevant.
All right.
Unfortunately,
In reading this and my recollection of testimony, I'm going to overrule that objection. $1586.
object relevance to that as well.
Statement argue about the relevance to 1586.
Yeah, I'm looking, Your Honor. Yeah. This is one where the lead-up is into basically George telling them that the only reason they ever gotten into trouble is because they cave and crumble, and he's not gonna cave and he's not gonna crumble. He's gonna go on the offensive. You know. Again, you're talking about, you know, the investigation and, you know, him telling her what to say and do to others. And again, I would just say overall, Your Honor, you know, again, this is George's comments, and we've had testimony upon testimony that they know they're being recorded, and in fact, I think some of these you've probably seen, George flat out says he knows he's being listened to. So, again,
I'm going to overrule the objection, permit 1586 to be played. 2085 is actually not a recording, correct? It's a
yeah, that's just the attachment that was sent. So it has already come into evidence,
So
so.
we don't object to that one. Back to 1586, or just one, and this may be a comment that can be applied to future.
What about it?
This may be a comment that can be applied to multiple
Okay.
recordings. There may be language in this one, for example, that could be considered a threat or improper other act evidence towards individuals. So we would object to improper other act, as well as not a true threat. I think it's more clear than other.
Yeah, I think that's probably more clear than others.
And others, but I think it could be interpreted that way here. So, you know, just to make a record now, so it can apply to future ones. You know, just because they're something that can be considered a threat, it has to be under case law, it's called a true threat, which means it must be specific and it must be intended to communicate fear to the other person. And I would point the court towards Virginia versus Black out of the Supreme Court, and also the United States versus Alvarez out of the U.S. Supreme Court, 567 U.S. 709, which is a 2012 U.S. Supreme Court case, and just point out that none of the charges against my client involve making threats. Nothing in the indictment involves making threats. He's not charged with menacing or threatening a law enforcement officer or anything like that. But some of these calls contain what could be interpreted as threats. We don't think they're relevant. We think it's an improper attack. They don't meet this true threat test that they're imminent, especially, you know, these are recordings where George is traveling across the United States, God knows where, you know, in his truck with his brother doing the trucking business. So he could be in Montana, he could be in Wyoming, he could be in California, he could be anywhere. So whatever he says that may be interpreted as a threat is not a true threat under the case law because it's not him. And so I think this is going to come up more explicitly later, but I think it could apply to this call. Towards the end, I think there's some language for the transcript. So I just want to bring that to the court's attention because we'll be incorporating that as well.
All right, the state's responses.
Well, Your Honor, pretty sure we included that in our other acts, evidence, but also making threats to law enforcement that are investigating you, what we would argue is indicia of guilt. And we should at least be allowed to argue that. They can argue in closing arguments that it's not relevant, or it's understandable, or it's
Well, explain to me what the relevance is.
indicia of guilt, if you're threatening law enforcement that's investigating you. But that's not all that was relevant in that. I mean, they're interpreting that.
There may be other parts of the conversation that are relevant, but those portions where there's a threat should be excellent.
So is that the purpose for which this one is being submitted, or is there something else in there that the state feels is relevant?
No, this again is that he is scolding her and saying, everything, you're gonna hate when I say this, everything that you and Dad never got in trouble for with them motherfuckers, the only reason they never got away with that crap is because every time somebody came, everybody crumbled, and it came and it crumbled.
So your argument is that indicates some indication that they need to hold the line on that.
Yeah, it's not consent.
I'm going to overrule objection 1586 and permit that to be introduced. Now, this isn't a recording, so I'm not sure why this is here.
It's just because it was texted, or it was sent from George to Angela, and they have some discussion about it, so it's really just
Oh, this is in what?
it's not attached to any one of those things, it's its own separate text, you know? It's kind of like later we have, well, I guess we probably don't, because we had,
You said you did not object to this one.
Judge, it's already in evidence through, I think that's,
Yeah, I think it is.
so I don't understand the purpose of it now.
But on June 3rd, 2018, it went from this defendant's phone to his mom. So the fact that he had knowledge of it, the fact that it's on his phone is
I know we testimony to that. But
it's on the cover sheet with that is where that texting from, yes, that's why we have.
So you're not objecting to it or are objecting to it?
The document itself is already in evidence. I think it's repetitious.
So I will overrule the objection to that. $28.51.
2851, we have no objection.
$33.27.
3327, we object to relevance. This is a conversation between Sharik and Angela, where there's some discussion of Pike. That's program of homicide, what it is, and so therefore should be in.
You're on the evidence as far as the state's concerned as far as?
Well, planning for their arrest, Your Honor, and noteworthy is that they're planning for all four of them to be arrested. And Jake was referencing the conversation he had with George. And again, it's just evidencing all, again, they're intertwining as far as making group decisions and all that stuff. I mean, George is telling me about the what's and whatnots that he had talked to you about. Go ahead and just put everything up for Grammys. I mean, again, these are group decisions, which is a big part of the state's case, and the opposite is a big part of the defendant's case. And again, they're making a plan for their arrests.
Well, it's a conversation between Jake and Angela, who had pled guilty. Not only that, but it's not in furtherance of the conspiracy, so it would be hearsay. It doesn't mean an exception either.
I'm sorry, the last point was what?
So what I'm saying, it's a conversation between Jake and Angela. Whatever they're doing, they've already pled guilty. So whether they are in concert or working together, that's up for debate. And whether you can extract that from this conversation, it doesn't involve the defendant. Not only that, but this conversation is hearsay. It does not need an exception because this conversation is not in furtherance of the conspiracy. Assuming there's been an independent change of behavior.
I'm going to sustain the objection as to 327. 229.
229, this one is, George, we've addressed this argument earlier, but George addressing, talking to Jake, talking about, you can go suck your buddy's big black dick.
Let me ask this question. Is there other evidence in here that George Wagner here and Jacob Wagner were aware that they were being listened to? Is there other evidence in this case than that? Were aware that they were being listened to?
Well, Jake testified to that.
I'm sorry.
Jake and Angela testified to that, or Jake, I mean, he said he is.
Here's my point with this particular one. This is one that's always a little difficult to people to understand, but 404 or 403 A, although relevant evidence is not admissible if probative value is substantially outweighed by the danger of unfair prejudice. I'm curious about this particular one. If we have evidence in that they know they're being listened to, and if that's the reason this is being brought in, then its probative value would be lessened by the fact that we also have other evidence in the case that they knew they were being listened to. And frankly, the other things mentioned in here would have, I think, a substantial prejudicial effect.
Your Honor, first of all, the evidence that we have are Jake and Angela Wagner. I don't think the defendant is willing to stipulate that everything that Jake and Angela Wagner said is true. I mean, we have the right to corroborate this. This is George's statement that he knows he's listened to it. It's also George's statement that the remaining of these comments, and again, threats to law enforcement is absolutely probative of the consciousness of guilt of the defendant. I mean,
I'm sorry, how does knowing you're being listened to?
No, the remaining of the conversation. The fact that they know they're being listened to means they're throwing their conversations, which applies to a lot of the other things that they said. For instance, George insisting this is a wish list with that gun list because he knows we're listening to him. So I mean, this comment by the defendant himself acknowledging that he knows we're listening to him is extremely relevant, hyper relevant. And I see zero prejudicial value to that statement coming in. The remainder of these is, he's making direct threats to the lead agent on this case. And I might note for the record that, these were perceived as very real threats such that there was security detail placed at our lead agent's house. So, I mean, there is, I mean, again, making threats to law enforcement in general, but the law enforcement officials who are investigating the case, he says he knows Ryan's listening to him, and then proceeds to make threats to him, calling him out by name.
Judge, there has to be some evidence to the threat for it to be real. Here, George is in some other state, working on the truck.
And sometimes they plan their murders, months in advance.
Judge, the rules are the rules, you know? And whether,
Well, this isn't this isn't the entire tape.
We're happy to play the entire tape, Your Honor. We're trying to isolate, first of all, to relevant information. I mean, I doubt that this is from the truck. So they'd be driving the truck for days, right? So I mean, to isolate, so I mean, sure, it's not the entire thing. I don't know what comes before it. I don't know what comes after it at this moment. I can certainly look, but in this excerpt, he says, Ryan, I know you're listening to this, and then he proceeds to issue threats, specifically saying, I don't care, Ryan, one of these days I'm going to bend you over and make you like it, and, then proceeds. So, I mean, he's calling him out by name.
Well, I'm sorry.
I'm sorry, go ahead.
The part of this tape that indicates, or the recording that indicates that George Wagner knows that he's being listened to, I think is relevant. I frankly feel like the rest of it is a rant and not a threat. It contains threatening language, but it obviously is a rant. And I feel, and I think that is, for the probative value, the rest of that, frankly, is substantially outweighed by prejudice. Now, the part that indicates, since this is the whole thing anyway, you have the pen, you have the scissors. I mean, the part of this that you're offering does not have to include that, to include that they know they're being listened to. That part, I think, is relevant. It fits, you've indicated that part of their conversations were based upon the fact that they knew they were being listened to. And I think that's relevant. I think the rest of it constitutes a rant, and I'm not sure if it was put in there for that purpose, but I suspect maybe the state did put it in there. I'm not, it's not a threat, an immediate threat, and it's probably not even something that would ever be done. But it is a rant. He obviously is upset when he says it. So the court would permit the part that indicates that they understand they're being listened to. I'm a little curious, though, why that is where it is in this recording, because if they know they're being listened to, it would seem like that there was some conversation going on before that they know is being heard by law enforcement that isn't included here. I can't be sure of why that's not there. But, so what I'm telling you is the court will permit the part to be played about being listened to, but the rest of it I feel is substantially outweighed by the prejudice involved in it, and I therefore would not permit that. So you do with that what you will partially sustain. Now, 3851.
3851 is a conversation between George and Chris Yippo. They're talking about Olympics, which is probably referring to something else, but George says, I can't do that, or I have to postpone that. So we question the relevance of that to homicides or any other crime for which he's been indicted. Chris Yippo is not an indicted co-conspirator either. So that's not that.
it's very vague.
All right, the state's arguing about the relevance
Yes,
of
Your Honor,
3851.
because Jake testified that the Olympics meant coaching, and that's what they're talking about is coaching. And he's indicating, obviously, again, planning for arrest, basically.
Where does, I don't see a resident anywhere.
I should know something on what their plans are by October easily, and then I'll let you know. So right now, we'll keep the plans the same in case unless they do something. If they don't do nothing, it stays the same.
And we don't see, what is that program about?
I think there's actually conversations around this where it's explained that, you can't do that because you're risking stuff, you're gonna screw up or whatever by going and doing other illegal things.
Once again, it's for a region as well. There are no charges in the indictment.
It doesn't have to be charges in the United States.
But there are, and it's very vague, look like a number two.
Who's going to interpret this? I don't see, you said Hochi? Is that what you said?
Jacob testified that they spoke in code and the Olympics meant coach.
So that's based upon Jake's testimony that that's what that word means. There's a whole other testimony in this case, and that was one part of his. Is that's what Olympics means?
Yes. Right. They thought they were going to get arrested right before the election.
Say again.
They thought they were going to get arrested right before the election. There was an election that year.
I don't recall that testimony.
Yeah, I frankly not sure either whether that was in Jake's testimony. So I'll rule on that in a moment or two, but it seems to me that if it's necessary to interpret that, it might be necessary for us to see whether in fact that's what Jake Wagner testified to.
We can also go back to review this. I think there's more conversation in the same call that we could include that we can context.
We'll 51, we'll defer that for a moment. Thirty-seven, 39.
Yes, Judge, we object to this one, at the last page is a threat to Ryan. Our previous arguments covered that. And there's also, this is kind of a lengthy portion, if I remember correctly. The entire call is around 40 minutes. They included 10. But the thread at the very end is one part of it. This is a conversation with Jake and Angela, George at times, talking about that. And possible penalties that Jake and Angela might be facing. We don't think a lot of this is relevant at this point. We certainly don't think any threats that are contained herein are appropriate to them.
You said there was a thread in there somewhere.
On the last page, about a third of the way down, it's Jake and Angela talking. It says George in truck, unintelligible in their life.
But Ryan, I want to kill him.
Yes, Ryan, I want to kill him. On the last page of the
All right, the state's argument in this particular.
Again, Your Honor, this is them, and again, they're acknowledging that they know that we're listening to them. They're trying to throw the investigation, right? So I think this is part of the conspiracy of trying to cover up, because they're saying, I don't know why they've got a personal vengeance against us, et cetera. And again, this is Jake, George, and Angela all participating in this conversation.
Yeah, all right. I'm going to overrule the objections to 37, 39.
Judge, with respect to the threat, it's kind of a conditional threat, it's not a direct threat. And once again, George was in his truck out of state.
You're talking about the one statement there.
Yes, I think that should be excised.
That states how he feels about him. I don't know that it is a threat to do anything, but,
Right.
so, I'm going to overrule the objection. 5176.
5176 is also irrelevant, it's a conversation between George and his mother regarding his death. And specifically, it's the relationship between Beth and Jake. It's just complaining to each other about her. And so,
The state feels that this is relevant to issues in this case. How?
Yes, Your Honor, highly relevant. Because George, again, is trying to distance himself from the whole issues that developed between Hannah and Jake, that Angela, right, so, was involved in, obviously, and the state's argument is that George was invested in that same thing. This is strong evidence, direct evidence, that George and Angela are discussing the, welfare of Sophie with Beth there and talking about Beth, and they, they're basically, both of them, we talked about their paranoia. Angela, George's paranoia is evident here, and it certainly is going to be argued by the state that this very conversation was being had regarding Hannah and Sophia, et cetera. So this is highly relevant, Your Honor, because this is George and Angela talking about Beth and Sophia.
there's no connection to Hannah. It's just a conversation. It's not that,
It's hard.
like the situation
Case.
with Hannah. There's no reference to her. This is something else. We're still a different person.
Now it goes to the collective motive of the group. It goes to the common scheme of plan with respect to the identity of this defendant as part of the criminal enterprise conspiracy.
But there's nothing here about a conspiracy to do anything wrong in this
The
transfer.
common plan or scheme.
I'm sorry.
I said the common plan or scheme that you see.
Show me what this is planning. How this contributes to a plan.
Well, when it's dark, I want you and Bullrun and Beth to go in the room and lock the door and keep that in with you. Yeah. I mean, again, Your Honor, this is just the intertwining of these four defendants, and specifically, quite frankly, Jake, George, and Angela, where the state's argument is they don't make decisions by themselves. Decisions about, we have to protect Sophia from the Rhodens, we have to protect Sophia from that band. This is fodder for common discussion. And so, again, this is our entire case. I mean, when we start listening to these kinds of conversations that are being had about getting another female into Wagner's life, this was our other acts evidence that we talked about and argued, and, at least at that point persuaded the court, because, this is how they did Tabitha, this is how they did Hannah, this is how they did Diane. And, this is evidence that George is very much an integral part of that.
There's never any harm done or intent on.
Because she left.
They gave her a rat.
It's the state's theory of the case.
You're saying the theory, I'm talking
Well,
about the
it's
evidence. I'm talking about the evidence.
But this is.
The evidence is they gave her a ride so she could do, not that she fled.
They push her.
Is
Guys,
that-
the evidence by
is
the
it a
main.
crime for people to decide that they shouldn't be living together?
Well, it's not a crime, but the whole reason was because George was convinced that Beth Ann was going to sell Bullfine and Sophia to the
And
second
had
trade.
testimony.
Well, that's gonna come into this right here, that's what he's on.
It's not relevant.
It's highly relevant because it means George is protected as state, in fact, of Sophia. In fact, in one of these, he tells him that you can leave, but you're leaving Beth, or you're leaving Sophia with me because I'll protect her and you won't.
So a man doesn't want his niece to be with a woman who he suspects of being a
Just
child
like he
abuser.
doesn't want his niece to make the Rhoden.
And ability to kill for it.
Exactly.
That's not here.
That's not here. There is no willing to kill
That's how
Beth
this is
here.
unfair. That's not here.
There's absolutely nothing here to say Beth is going to be killed or harmed in any way. Do they have disagreements? Yes. All right? Because Sophie tells Angela that she was improperly touched. Is it a crime for the uncle to not want her? Want her
So I wonder what happens when he finds out that allegedly that's happening at the Rhoden. And
You're
it doesn't matter.
making a huge leap to killing
That's your
versus
argument,
protection.
that's your closing argument.
Well, that's
It's
the
kind of
flaw in
like-
your case.
It's not a flaw. We had Jake and Angela testify as what happened. And Angela said that the protection of Sophie was very much part of George's motive. So, again, Your Honor, this is strong evidence of the whole theory of the state's case that the welfare of Sophia, he considers his responsibility.
At some point, this becomes cumulative and unnecessary.
And unnecessary. What evidence has come other than from the co-defendant so far?
All right, the court's going to deny the objection. I look for the- Strong as might be. 260.
260 we object to. This is similar to maybe, I think maybe 3 or 4 of the transcripts we've had already. This is George in the R&L truck speaking to Jake and complaining about that. It's another one of those we'd say is irrelevant.
This is the exact same, Your Honor.
Well, if it is, it's cumulative.
The only ones you basically have, mine, son's, mom, me, and dad, that's it. No matter what it is or who, that's the only ones you can basically count on.
And that's probative of,
Of the fact that he wasn't trying to get away from his family like he said in the lead statements.
Statements are.
They are evidence, but we have to prove that they are incorrect, and that's what this does. And he wouldn't be objective if it wasn't damaging to your case.
no, we're just trying to save time to not go
Well,
over a bunch
we
of
could
needless
play it right
transcripts.
now.
It's not in trouble with the evidence as well.
All right, I'm going to overrule the objection. 80, or 2207.
2207 is another conversation between George and Angela. It's not even clear what they're talking about. And so because it's unclear, we're asking that you move this for as irrelevant.
It's the writings that, the ones earlier that they didn't object to.
Say it again.
The writings of Beth Ann's, it's Mama is Rita, and that's who, at some point they say that she found it in the trash, that Rita found those writings in the trash.
Because only writings go in the trash can, I guess is the assumption. I mean, what are they talking about?
I just told you.
Because you were there?
Because there's 100, if you want me to get the other,
Cumulative evidence? It's just unclear. It's unclear. It's
the other
irrelevant.
recordings that made it clear, I'll be happy to do that. We can
Are
get
you sure you would have
recordings.
used them?
All right, I'm going to sustain the objection to this one. You'd have to reading a lot more into this conversation than it has in it to understand it at all. We're talking about it, if we're looking at the same one, Mama's gift, safeguard.
Keep it with you, don't lose it. It's Bethany's, rights.
To sustain the objection to that. Um, 4744.
4744 is a conversation between Angela and Jake. They're talking about Tabby's Facebook. Again, not sure the relevance to that.
This is Angela telling Jake that she wants him to ask George for the password to Tabby's old Facebook page so she can monitor it again for him. So again,
Doesn't say.
All right, I'm going to overrule the objection. 5539.
5539 is, it's a phone call, the voicemail picks up, there's no message left. You can hear a voice that says, Jake, you've got nothing to worry about. That's your problem.
yeah, I don't know if, I will listen to this, because I thought that the unintelligible was intelligible.
So I'll sustain the objection to 5539. And 719.
719, no objection.
$55.80.
No objection.
$52.95.
This one we would object to only because it's Jake on the phone with, I think somebody from Marnell regarding wanting to come home due to a family emergency. That testimony's been admitted, it's been uncontested, it's just more cumulative evidence. But more so the issue is it's improper bolstering, or it's just a prior consistent statement. And so that's the one that we ask that we would do this.
Your Honor, it's not being offered for the truth of the matter asserted, it's being offered to show their reaction to Ryan texting the photograph of Jake holding that 1911, and again, Jake testified about it,
Right.
Again, if you want to stipulate that Jake said it's true, then we wouldn't have to bring it in.
Well, overrule the objection. 2620.
2620 is another objection. It's just more evidence of a prior consistent statement that came up. And there's been unrebutted evidence in some aspects, and it's as if I don't know there was an anticipation it would be rebutted, so these transcripts were created, or maybe the prosecution is just wanting to pound certain things home when it's unnecessary, that would be improper. But this one deals with Angela complaining about Beth being poisoned. And so, that's their witness. They elicited, the state put this witness on, elicited that testimony, and now they want to introduce this transcript just to drive home the statement that they brought already with their own.
Then it really is to corroborate that George knew about it, and he says she's putting some kind of drug in that, so if they do arrest us, they can find kind of drugs in the system. So he buys into his mother's quote paranoia, which is highly relevant in this case. And, you know, he talks about the papers again, and says that he wants Mama to have a set, and Renee to have a set. I don't care what he says, I want John to have a set. So again, it's all this, you know, cooperation, them working together.
That's a far cry from murder.
And John is
Well,
referencing
one
the
wouldn't think
attorney.
that murder would happen over what it did, so, this is highly relevant to that. Again, it's we talked about, again, during our other act stuff, the way they treat these girls is all the same, right? They accuse them of being abusive, they accuse them of poisoning them, they accuse them of all sorts of things, they isolate them, they try to take the children from them. So again, this is highly relevant, Your Honor. It's the defendant's statements. He's buying what his mother is selling, hook, line, and sinker, just like they did when they decided to murder the Rhodens.
But this adds nothing new to the testimony that's already been.
Well, it does because George clearly knows about it and clearly believes it. And tells him that he wants the papers to be kept.
We'll overrule the objection 2620. 543.
543, this is consistent with the objections we've been making regarding the gun list. It's in violation of Thomas. It's a gun list that has been repeatedly been introduced, again, and it's cumulative as well.
And it's the reason why we have said that the gun list comes in is because George keeps insisting it's a wish list because he knows we're listening to him. Because the SKS is listed as belonging to him.
Overrule the objection to 543. 6197.
6197, we object prior consistent statement, it's been unchallenged by the defense. Regarding the photograph that Angela looked at.
And this evidence is that George knows that that occurred, and he's also falsely saying that this is not Jake's hand, when he knows darn well it is. So this is part of the conspiracy, part of the cover-up, they know that we're listening to them, so he's trying to convince us that the gun, or the hand pointing to 1911 is not Jake's hand.
Overrule the objection to 6197. 502.
502, we have no objection, only that the entire report be played, put this transcript in the context.
I don't know what the entire recording consists of.
The recording just helps put these statements in.
Is this something we need to listen to?
Yes, I'll have to listen to that, Your Honor, but I don't know that I necessarily disagree with that. In fact, I think I wanted more into, but didn't wanna, it's already really, really long. But, because this is in the, you know, it's in the
So
vehicle.
let's screen that for now. 1505.
We would object to this. This is a transcript of a discussion between Jake and George regarding that sex. That is Jake. And so the question of relevance of this.
Your Honor, the opening line is obviously extremely relevant. The family has spoken. The family has spoken. She's not living nowhere near us and knowing where me, Mom, and Brian live. This is the one where he is, you know, first of all, evidence is family decisions. And they're deciding about whether or not that can be, and he's here telling, George is saying that.
I'll overrule the objection to 1505. 11609.
This is a conversation between Angela and Jake where George thinks he would like a ribeye steak or a steak. And that's, that be ruled inadmissible, it's irrelevant.
Oh, this is where, Angela is telling Jake to tell George that, he's got to quit drinking caffeine and taking bath and bodies, and he's going to screw up because he's, talks too much when he's on the caffeine.
Talks too much.
Well,
So,
they're gonna screw up.
Yeah, I'm sustaining portion. Fifteen, 811.
1511, you would ask that this one be ruled inadmissible, it's irrelevant, it contains threats, prejudicial effect on use of property value. This is, again, threats. Then,
This is in regards to us serving them with subpoenas for them to come and, to the grand jury and give their shoe and palm print, Your Honor.
Say again.
This is when we serve them with the papers to come to provide their, foot measurements and, palm prints.
It's not reflected in this transcript.
Well, it says that, again,
It has more to do with perceived impropriety than trespassing.
well, again, you can argue that.
but that's what makes it irrelevant, it's, it doesn't address.
Your
what you just said.
interpretation does not make it irrelevant.
It's so vague that it is a interpretation.
I suspect we can tie it through Julia to when the papers were served. With the date of the call.
Even portions of it are relevant to what the prosecutor says, and clearly statements in here that are lacking in evidentiary capacity.
Yeah, at the beginning, it says, Mom's gonna tell the judge when we go, so it was when we served Rita, and
Even if you get by that, there are other statements in here very
There's quite a bit of reference here on the last page, asserting the right to counsel also.
well, again, one of the things that they did earlier, when Angela was on the stand, was say that George wasn't using the attorney. That was a big point that they wanted to make with Angela, that George didn't go to the attorney. So the fact that George is directing his mother, this isn't right to counsel, he's telling his mother what to tell the attorney.
And so what's wrong with that? What's wrong with them consulting with an attorney when they're under
It's not being
investigation?
wrong, but you imply that George didn't have anything to do with the attorney because he's innocent.
I'm going to sustain the objection to 15-811. 15-816.
What's that over?
158-16.
Once again, at the beginning, this one is George's reference to John, the attorney. It's a restraining order. It's PCI, I believe, it's education.
Well, someone's just smashed Ryan's head. His mom reminds him that we're listening.
It's the policeman, various things they do, she gets. Excellent.
Okay, Your Honor, this is not conversations with an attorney. This is,
Guess what?
this is not a conversation with an attorney. Again, this just shows the group involvement with all of this stuff. This is in direct response to our investigative activities that we were taking, that we had to tell the court that would provoke relevant conversation, which we would submit. It absolutely provoked relevant conversation.
Once again, this has more, this is more similar to the rant that the court referenced earlier, especially when Angela says, George, you're upset at me. It's not.
Well, and just, you know, because he says he's going to visit Ryan. I mean, you know, again, this to us is very indicative of guilt, and it's both of them talking about the investigative activities that we were doing. And again, it shows that he and Angela are both involved in this. It's a defendant's statement.
Because it says statement doesn't mean it comes in. It has to have something relevant, it has to be probative or disputed fact.
Well, we believe it is probative of the fact that he was very much in the thick of this. He certainly did not, never hear about it, or never discuss it, or never, you know, whatever.
Yeah, he knows his family's under investigation, right? He's been questioned at the border.
But he's telling his mother what to do, and he's also
So they're
saying
calling
what,
the lawyer.
saying what he wants to do to the lead agent. Again, that is strong indicia of guilt.
I'm going to sustain the objection to 158.6. Because that reference there, talking to his lawyer and so forth. I'm assuming it's for that.
So I guess, Your Honor, at some point then, I would like to request a stipulation from the defense that George considered John Clark his attorney too, because they made an inference when they questioned Angela that it was only hers and Billy's, I think, and that George never went and talked to him or never had any interaction with the attorney, implying that that meant that he was not worried about any criminal culpability. But now they're saying very much that's his attorney too. So I would like a stipulation that says that. Otherwise, we should be free to demonstrate that to the jury. You know, through this evidence, which is the only evidence that we have available to demonstrate that.
76-71.
Judge, this is a conversation between Angela, Wilma Beasler, and Rita regarding acquiring an attorney for, I think, an encounter with PCI. This might have been when you had a writing sample, but it's just, the conversation is about an attorney, getting an attorney. And so you ask, this to be used in this. It's not relevant.
I'm going to overrule the objection to 76-71. On 7306.
Our only objection to this one is that it leaves out a portion of about 2 minutes of conversation. And on the transcript, it ends at 3:51 and picks back up at 6:15. We ask that way to put the rest of this in context. It's only 2 minutes.
It did seem to be a good bit left out. I'm not sure why. Council knows.
Yeah, Your Honor, we can listen to it and make a decision on that. Again, this was a combined effort between the analyst and ourselves. We try to keep it to relevant conversation, so if there's 2 minutes of irrelevant conversation, we tend not to include that. but I don't know what's missing there, so I will certainly have to have this.
So we will defer that. All right. Is this 252? Yes, 252 is the next one.
Your objection to this is irrelevant. This is just a conversation between George and his mother about going to the sheriff's department to provide foot impressions. That's, nobody's denying that happened. So, irrelevant.
But one thing this may answer for us, at least partially, it says here that if John refers to John Clark, I just want to tell you, John texted he would be there Monday. Okay? John did for everybody, for me and Jake. We'll be there for Dad. Why? Because, but it looks like he would have been, but there's a time element there is the next this.
Plus, at the end, there's some inflammatory language that's not relevant to. Yeah. It's not prohibited with anything.
What's the relevance of this?
Yeah, Your Honor, again, just the board of them working together.
Well, to get counsel in this particular thing, I think, so I'm going to sustain the objection to that. $214.
Judge, this is another one which we received on Friday. This is referencing beyond the attorney serving subpoenas. I don't know if this is appropriate, though. It's a conversation between Jake and Angela primarily, or exclusively between Jake and Angela.
What's the relevance of this?
Your Honor, I don't know strongly about this one.
So I will sustain that objection. $198.
No objection to what we do.
We do object.
No.
Can't read
Focus
my
on
writing.
inquiry presentation.
Yeah. can't read my writing. We do object. This is Frederica D'Angelo talking about legal representation, logistics, concerning the meeting with the lawyer. Almost. It really doesn't have any relevance to anything. These people are planning to get legal counsel while they're being investigated. What's that program? They talk about the cost of the attorney.
So unless there's good reason, I'll sustain that objection too.
Your Honor, this one is, she says that, Frederica is saying that he was gonna get one, she was gonna get an attorney for Jacob, and here's Jacob, and all off the book. Angela's response is, I don't know, he keeps saying that it's not that way, this is a foursome thing. So again, just intimating that they're all four involved and they're anticipating arrests.
Intimating all four under
Well-
investigation.
I'm going to sustain the objection. Sounds like they're tactically deciding how to be represented. And I don't know that that's relevant to anything. It's sustained 198, 344.
344 is, well, as the context states on the first page, George and Angela Becker discussed legal representation. She's going to have a conversation regarding an attorney and who will get which attorney. And so you question that.
Yeah, Your Honor, this one we feel is very relevant. Again, this conversation between George and Angela. Again, just talking about getting an attorney does not suddenly make it off limits. They're not even saying the name of the attorney. They're not saying, the attorney-client privileges is when you're talking to your attorney and you're saying, confidential information. This is talking about who should get the best attorney. And here, George is saying that the only one who can manage to take care of the kids by themselves, they need the most is you. The rest of us can screw ourselves. And he wants his mother to get the best attorney because he wants her to be able to take care of the children. And again, I think this one is highly relevant and goes to the state's argument that they were all four involved, and George is wanting to make sure that his mother gets the best representation, as opposed to himself.
That's certainly a crime to let your mother get the
It's
best
not a crime,
representation.
I didn't say it's a crime, I said it's relevant.
It's not relevant to anything in this event.
Chairman, what this is, there is some relevance with this with respect to how it mirrors the custody documents. Again, the custody documents that they executed before a homicide basically indicated that it's those same types of wishes. Hey, look, if Jake and George become unavailable, this is what we wish to happen, whether it's killing versus getting arrested. So there is relevance there with respect to the wishes both before the murders and after the murders. Part of the ongoing conspiracy.
But there's been no argument that those custody documents were forged and false. That's not an issue in dispute, so this doesn't help.
It does help, especially because, again, you guys are saying he's trying to distance himself from his family. In July of 18, he still is very much a cohesive unit with his family and still very much wants those wishes that he executed in April of 2016 to be carried out.
Judge, I mean, this is after the Montana interviews. Everybody knows everybody's under investigation. They were stopped at the border and interrogated for hours. They've been consulting attorneys. They know they might be arrested or one or more of them might be arrested. How's it relevant that my client says, I want my mom to get the best attorney, number one. Number two, so she can take care of the kids in case the rest of us get arrested or I get arrested.
Exactly.
How is that relevant to the murders here? All right? It's not programmed with anything.
It's the same plan. It's the same plan before they went to the hill. If something bad happens, mom, you're going to take care of the kids.
And it also,
Well, his wife certainly, the courts ruled that his wife can't have the kids. So, I mean, somebody's got to take care of the kids.
it also shows, again, their cohesiveness and their group effort in order to,
I'm going to overrule the objection to 344. 793.
793 is a conversation between Angela and Jake. You don't object to that.
Seems to be discussing legal advice. I'm not sure what relevance of it is to the states.
I think he said he doesn't object, Your Honor.
People,
He doesn't object.
We just said there was a conversation between Jake and Angela, so we don't object to their conversation.
But guilty, right?
okay. 823.
823 is a conversation between the defendant and his mother where they talk about moving out west, moving to a different location. I suspect the state is going to argue some type of cohesiveness which is just cumulative of the other 15 or so conversations that we had. We asked that it would not be, but it's cumulative.
State argues what?
Yes, in July of 2018, he is still very much not, they said he ran away when he was 16, and ever since then, been trying to get away from his family. This is evidence that that is not true. And again, it makes it more likely than not that he was part of the group of 4 that were involved in these homicides.
All right, I will overrule the objection. That one. 1366.
1366 is a text. And are you okay with the fact that I'm really close with the game in terms of most people that game is something really have to write? There's no trouble writing to that. It has to be moved in this way.
I'm not even sure what it did.
It's a text to, it's from George, a text to his then, I won't say girlfriend, but the girl he was talking to. And again, just says that he is really close with his family, not, I hate my family, I'm trying to get away from them, I can't stand them, they're terrible humans.
All right, I'm going to overrule the objection to 1366. 1853.
1853 is irrelevant. It's George and Angela discussing advice from an attorney. And so the relevance there is discussing when an attorney is going.
I don't think they're talking about what I'm sure.
That's what the context you've got there on the front page.
I don't have a context.
Unless somebody was able to, I mean, if this is coded language, somebody's going to have to explain it, otherwise I don't see any reference to it.
Just again, him going off and mom having to remind him to watch what he says and.
So you're not, I mean, there's no, I see a lot of reference in here to a book, using the book that's tried and true, and I'm not sure what it is we're talking about, unless somebody can do better with that. So I will, at this point, sustain the objection to 1853. 2613.
2613 is, it's a recording from one of the devices placed in the RNN truck. It's just, it appears to be an argument between Jake and George regarding their children and their children. That would be Bullline and Sophie arguing or fighting with each other. And so the two fathers are arguing about that. That's got to be ruled indivisible as irrelevant.
It looks like from the third page of that it began over possibly Bovine hitting Sophia, that she may have hit him first. That's what it looks like the fathers were arguing.
Okay.
And I didn't see the relevance of it. So unless the state has some argument to make, I'm just sustain it. All right, sustained then is 2613, 2673.
2673, we are objecting to that. For one, it's confusion of the issues. The state put on their own witness, their key witness, that all evidence of clothing was burned. And so this statement talks, it's Jake essentially saying that he bought a winter soldier mask for George. And So that's it, just that there was a Winter Soldier mask bought, and I think the mask was bought far in advance of 2016. And so why is that being brought up? For one, it's not relevant, but why is it being brought up when the only witness says that everything's destroyed? So it's confusing, is there a Winter Soldier mask involved in this, is there not? So confusion of the issues, irrelevant, that's it.
Yeah, it's relevant because it was purchased on April 9th of 2016, less than 2 weeks before the homicides. And it's purchased, it's a PayPal account associated with the Wagner family, et cetera. And in this particular dialogue, they're acknowledging that it was bought for George. So we think that's relevant. They're buying the mask less than 2 weeks prior to the homicides. Whether or not he ends up using that or not, I don't know, I wasn't there. But we don't have this in our, we didn't find it there.
So what is the probative value of this?
Because the homicide and he bought his face.
So I heard the state say they had no evidence it was used. The state also elicited testimony from their own witness that any point of was burned, so.
We don't have.
I'm going to overrule the objection to 2673, or excuse me, yeah. 2673. Yeah, overrule the objection to that. And now we have 3164.
Only objection we have is that the first portion of that conversation has been deleted. To put the remaining amount that the state wants in the context, we've asked that the first portion appears to be the first 13 minutes be played.
Well, I'm not sure how much there is. It looks like 1310 was in, so it'd be what, 1:10 p.m. And then we have 2:55 on page 3. There's something gap there too. She said something before.
Yeah, according to the transcript I have, it indicates the conversation picks up at 13 minutes, 10 seconds. We would just ask that that initial 13
Oh,
minutes.
that's not the time, then. That's
I believe that's the timing on the recording, how many minutes of the conversation.
a couple of minutes right now. The state probably doesn't know. So,
If you have a third page on that, you may have one stapled, we may have stapled it next.
Okay.
Yeah, I can see it for the page.
Which might explain why.
Oh, okay. Well, that might be my 3170. Is that one that I thought I didn't have
Yeah,
yet?
it's coming up, yeah.
Okay. All right.
That could have been our fault too, because we probably saved those for you.
So 3164, then, the state will listen to determine whether there's something else there that might be usable. Drill on that later. 3309.
3309 is a clear recording between George and Angela. The state is asking for less than a minute of what is a much longer recording.
Do they talk about up detectors anyplace else in that recording?
It's a 32-minute recording, and they're picking out less than 60 seconds between 11:35 and 12:28. We think the remaining of the recording should be played and put everything.
It sounds like we have listened to that. Do they talk about the bug detector or anyplace else in that conversation?
There are other things they talk about. Should be put in the context.
Well, we can listen to that, Judge, but I'm not clear how anything else that they're talking about would be relevant to the bug detector, which again, used, this was purchased, if you'll recall, with George's credit card, and he's taking ownership of this bug detector, so.
Yeah, and it sounds like that much may be relevant, Kate, but maybe council could listen to the start of that, see if there's anything else that needs to be included so that we don't have a misconception of the conversation. 5923,
5923 appears to be a conversation, recorded conversation between Bill, Angela, and G. It appears to be a conversation that occurred after Special Agent Shiner sent the text of the gun, but there's just discussion and nothing proven about it. Oh, okay, yeah, you have a picture of the gun that was going on about, right? You have your phone, did you? And there's nothing proven about this, other than did you get that picture? And so,
Now, this one is in conjunction with the following one, the 3541. Again, it's just showing the four of them working together in reference to the investigative activities of the CI. Jake is calling, or Billy's calling Jake asking for this, and wants to get it from George, and he does get it from George and sends it on to, George sends it to him, and then Andy.
Need to remember the context, all four were interrogated on 10/4. And now one is receiving a text, they're all saying, what did you get? Can you send me a copy of that? How is that indicative of anything?
This is actually 2 months after.
These are clearly co-conspiracy agents, basically working together to hide the existence of the conspiracy.
How are they hiding these?
We gotta get taken care of, so. It's important.
we can't hide, it's a permanent record, it's there in the phone records, there's going to be video.
It was sent by BCI to George. And the other family members are saying,
There's some urgency that his co-conspirators wanted it.
They got a formula plan to figure out how they're gonna deal with it, covered up.
they're extrapolating an awful lot from this very brief argument.
well, do we know, you said that it went with 3541? Or did you do-
Yes, the very next one, so it's this,
Next one, 5923. It's the next one, 5923.
so 5923 in conjunction with 3541. So it's the same,
How do we know it's referring to the same thing?
well, so you got a picture of the gun on your phone and have them anywhere. No, they texted one to George. And then, the next call is, same day. I wanted to make sure you got that. George sent it to me and I sent it right over to you. Okay, blah, blah, blah. So, I mean, they're in conjunction with one another.
Again, the relevance is what? That
The picture is of the gun used, one of the guns used in the homicides. And Billy has some urgent need for it, and he's getting it from, he calls Jake and, asks to get it, and that results in George sending it to his mother, who sends it on. So again, just the four of them in conjunction in regards to this critical piece of
All right,
evidence.
3541, defense would argue,
It's the same argument that both, because actually they follow each other, there's only a separation of maybe 40 minutes, but it's involving this text message that was sent, but it's just sending that picture of that gun. 3541 appears to be a conversation between Billy and Angela. Billy says, I'm in his parking lot. Angela, oh, you haven't been in to talk to him yet? Billy says, I know, Angela, oh, okay.
We believe that's the parking lot of his attorney, so he's looking for the gun to take it and show his attorney.
I'm going to overrule the objections to each of those at 5923 and 3541. And then we have 3171.
This appears to be a recorded conversation taken from the above painted in the Arno truck. It's just George and Jake talking about who's watching their kids or who's the kids and who's watching their kids. Yes, that would be really good.
How is that relevant?
Yeah, Your Honor, it's really that last statement, just that, you know, it's our kids and I'm not staying out of it.
I will sustain the objection to that. Forty-five 72.
This is a conversation between George and Angela. Appears to be talking about the piece of property that they own.
Again, Your Honor, same argument that as of now, August 25th, 2018, George is still very much part of the family, made about the place. There's an additional caveat to this, because, you know, it's a cage system apparently that could come in handy, according to George.
All right, I'm going to overrule the objection to that. Let's get down through these here just a minute and see. That's make sure that I have the same questions here. 543, court sustained the objection to that. 464.
Oh, yeah, okay, sorry, I had written, sorry, I'm sorry, Your Honor. I had comes in, but then I remembered the court.
That's all right, speak up, let me know. It's not the
Yeah.
same. 464, the court overruled the objection to that. 471, there was no objection. 621, there was no objection. 626, deferred on that. We'll look at that later. 44, the court overruled the objection to that. 150, we're also going to look at that later. 1436, the court overruled the objection. 1586, overruled the objection. 2085, overruled the objection. There was no objection to 2851. The court sustained the objection to 3327, sustained the objection to 229. 3851, we're going to look at later. Court overruled the objection to 3739, overruled the objection to 5176, overruled the objection to 260, sustained the objection to 2207, overruled the objection to 4744, sustained the objection to 5539. There was no objection to 719, no objection to 5580.
Your Honor, I have 55
39.
as something we were gonna, because I was gonna listen to it or something.
Say again.
That I was gonna listen to it.
Okay, is that 5539?
I
I think I just said I sustained it at this time, but we can use that one later also if we're going to listen to see if something.
Okay.
I think the main thing is it not be played until that happens.
Okay.
All right. And 719, there was no objection. 5580, no objection. The court overruled the objection. 5295, overruled the objection. 2620, overruled the objection. 543, overruled the objection. 6197. And then I think we're going to look later to see about whether there was more of the tape or more of the recording 502 that should be played. Defense was requesting that happen, I think. Court overruled the objection to 1505. Sustained the objection to 11609. Sustained the objection to 15811. Sustained the objection to 15816. Overruled the objection to 7671. Again, 17306, we're going to rule on later. I think there might be more of the recording that you should listen to. The court sustained the objection to 252, sustained the objection to 214, sustained the objection to 198, overruled the objection to 344. There was no objection to 793. The court overruled the objection to 823, overruled the objection to 1366, sustained the objection to 1853, sustained the objection to 2613, overruled the objection to 2673. 3164 and 3309, that you're going to look at to see if there was more of the recording need to be played in order to put that in context so as not to mislead or misconstrue it. The court overruled the objection to 5923, overruled the objection to 3541, sustained the objection to 3171, and overruled the objection to 4572. So, does that sound like everybody else is ready? Now, that's taken us longer than I would hope it would. Jury's been sitting down there for quite a while, so we want to bring them up and do anything today. How do you want to do this? It's like 3:15. We can go for about an hour and a half, but that's as late as we can, maybe not even.
Your Honor, I think the problem is that there are some of these that occur early in the chronological order that we were supposed to revisit. So as much as my analyst would kill me if she hears that I'm saying this, I would suggest that we send the jury home, come back ourselves tomorrow at 8 or so that we can iron out any of the kind of loose, so that we can start promptly at 9 and go full day. Hopefully get the state's case done in that day. I haven't done an assessment, of obviously there's less calls than when we started out today, so I mean, that will reduce the time.
Scheduling, we'll leave it up to the discretion of the court. The only thing I would point out, so you may not know, we have an expert flying in to testify Thursday morning. And so we're really hoping to get him on. If that's not gonna work, I believe he's available next week.
We'll get this done.
Yeah, I mean, I would like to get him on Thursday if possible. And I know that, for example, if the state does rest tomorrow, which is Wednesday, we still have to deal with exhibits, Rule 29, and these things will probably take a little bit of time, so I just throw that out there so we can try to figure out our Thursday.
Yeah, Your
Because we
Honor.
have our expert, and we have 2 other witnesses lined up, we'll be short, probably. But nonetheless, I just throw that out there because Friday's a holiday.
Yeah, Your Honor, I think, hopefully anyhow, with the flexibility that I think both sides have shown in this case, you for 8 weeks and us just recently, but, we're certainly not going to object to him calling him out of order, but I would hope we would be able to get Ms. Eversley done tomorrow, especially because I think it'll be a much more smooth presentation because we've already taken care of any objections. It should just be a matter of playing through these things. They already alerted us that they had this individual flying in for testimony on Thursday. We're happy to let them go. But our goal will be to finish our witness in our case. Now, as far as exhibits, I mean, obviously, we will rest subject to the admission of our exhibits. And so I think we can deal with that, I mean, quite frankly, maybe even Friday, when the jury is not going to be here, or whenever. I mean, I don't think it has to be on Thursday. I think they can proceed with their witness on Thursday. We can take care of that.
Well, the problem with Friday is that that's a day on the county calendar for a holiday on the county calendar for the employees.
Yeah, I do hope, we talked about this before, I do hope to, and I know the defense had talked about it too, to be able to just identify those exhibits that they're going to object to. I'm sure they'll a lot that they're not going to object at all to, and then, probably we can whittle that down. Obviously, they have to do their Rule 29 motion, we can do that after hours tomorrow, or, early morning, 8 AM on Thursday before the jury's here, obviously, it's not going to be outside of the jury. So I don't think this should upset that apple cart.
Just to move things along, it seems like it might be easier if the state can tell us which exhibits they intend to admit, so we can concentrate on those, rather than maybe hundreds or thousands that we've received. Some of them may be non-issues, just to kind of move it along quicker.
If as far as a defense, a defense witness, the witness that you mentioned testifying out of order on Thursday, is that something that can be done as far as the defense is concerned?
Absolutely, absolutely.
All right, so we'll have the jury let them go. Now, the only question I would have is 9, I really don't want the jury to sit down there waiting on us tomorrow to get to the point where we can call them up. So is 9 early enough, or should they come in later than 9? Or is 9 late enough, or should they come in later than 9?
I don't know, I
sounds
think
like-
if we start at 8, if that is an acceptable, to everybody. 9:30 at the, gives us an hour and a half if we, actually start at 8.
Are we gonna get any more recordings tomorrow, George?
What is it?
Are we gonna get any more recordings?
I don't know. If there are no more recordings, then we've been through them once. It does sound like there's about 1, 2, 3, 4, 5, 6, 7 though that you were going to listen to try to determine, or 8, maybe 1, 2, 3, 4, 5, 6, 7, 8 that you're going to listen to in order to determine whether there has to be more played in order to put everything in context.
I think we'll be able to do that, to be able to put a fine point on it and have some fairly focused conversations about that. Something, we may decide, we don't care about it or whatever, so.
Okay, so let's have the jury brought up. Are we ready to do
Yes,
that?
Can we get one down there?
We're just going to release them. I don't know if we need to
I don't object, Your
have
Honor, I don't know.
that
what this-
admonition that we normally give. I don't know if there's a way of, if there's a way to put her on the speakerphone, will that,
Somebody could FaceTime or something.
But Judge, if it's gonna be live streamed, or if the cameraman can show it on a monitor downstairs,
In the victim,
It's, excuse me, that's not being played in jury's room, the live feed.
no, okay.
is it in the victim's room? We could get the victims out.
Is it in the family?
Here they are.
Just have a go and sit in that room and watch the big TV.
This is the alternate number 1.
Yeah.
Jury
she's
for
an
me.
alternate jury.
You can take my phone down and you can do a FaceTime.
Well,
That, or the. Big TV one.
I don't have an objection to accommodating this juror for the limited purpose of instructing them to come back tomorrow at a particular time and bring their admonition.
we will have all but the juror, I'm not sure what her number was, but all but the juror has a problem with the knee. We will have, we can leave her down there, but it would be good if, involve Sandra in this or somebody who could get her in front of a speakerphone or something, and then I could put Sandra's phone or somebody's phone here on the bench. and talk to them. Probably should do that first, then bring the rest up here.
The phone's on do not disturb. The phone
Yeah.
is on do not disturb. I can call it out. Do not disturb.
Well, you're going to take it off, you know, just, I'm not sure.
Yeah.
I'm not sure I know how to do that. So,
Mayor, I think. Yes. What's your juror number?
B38.
You see. Ladies and gentlemen, I apologize that you have been in the jury room as long as you have. Some things take a little longer than we anticipate. You will be coming back tomorrow morning. We're going to excuse you for the rest of the day. And you'll be coming back at 9:30 rather than 9 o'clock. Tomorrow morning, you will be listening to some recordings. And it takes a while to get those set up, so that's the reason that you were starting a little bit later tomorrow morning. You're listening to a series of those. But I guess the good news is you're going home about an hour early. But while you are at home between now and 9:30 tomorrow morning, you of course are not to discuss this case among yourselves or with anyone else. You're not to permit this case to be discussed with you or in your presence. You're not to form or express an opinion concerning the case. Not to do any research at all concerning the case, either as to the facts or as to the law from any source at all. Not to review, listen to, view, or read any of the reports or accounts of the case from any source at all, and have no contact with participants in the case, either parties, counsel, or witnesses. Does counsel for either side have anything further you wish to place on the record before I excuse the jury? And I will note for the record here that juror number B38, who's having some problems ambulating right now, is listening to us over the speakerphone. You are there, are you not?
Yes.
All right. And so the instruction is your instruction too, as far as this instruction about going home this evening. Does counsel for either party have anything you wish to place on the record before we
Thank you.
excuse the jury?
No, Your Honor, thank you.
All right, then we are in recess until tomorrow morning at 9:30. Jurors are to report to the jury room. At that time, it will be brought up by court personnel. Please leave your notepads on your seats, wear your badges on the record. Thank you. I'm sorry. So, is there anything further, counsel, for your side?
What time do you want us here tomorrow?
8 a.m.
That's fine.
I was just going to ask if the court would indulge me, if I could read to you what's out, because we'll have to readjust the PowerPoint to reflect the court's rulings, obviously. I just wanted to double check my list of the definite acts. Can I just double check my list of the ones that the court has said are definitely out?
Yes.
So we can delete those?
Yes.
I apologize.
The ones I believe that are out are,
Your Honor, before you start, can I go up there? I'm gonna pull the transcript as you say that, as you call them on.
oh, all right, sure.
Because,
543,
okay,
3327, 229, 2207,
okay,
502, 11609, 15811, 15816, let's see, 252,